that the credit bureaus decide what goes on an individual's report is mainly through the personal identifying information. They get a report from Chase that says Joe Smith has a credit card account with this account number. They say, okay, we want to put that on Joe Smith's credit file. Okay, but there's a lot of Joe Smiths out there, right? So they say, okay, we want the Joe Smith who lives in, Brooklyn, New York, and the Joe Smith whose date of birth is 2/11/1960, and the Joe Smith whose social security number is, and they have the number. So by using address, date of birth, social security number, they would locate Joe Smith's file and put that information from Chase on Joe Smith's file. Okay, but sometimes the bureaus, they don't use all four of those items. They don't use date of birth, address, full name, social security number, or they use a different system. In other words, they say the social security number is similar to Joe Smith's. Chase reported Joe Smith, but a social security number ending 216. And they find a file for a Joe Smith ending 215. Often, under their procedures, that's good enough. That's considered a match. It's not an exact match, but they'll consider that a match. I don't think that's a good system, personally, okay? Because I've seen too many people that they have the mixed file. So that's what I call loose matching procedures, not requiring an exact match. Second thing is not using multiple identifiers. This is very common in criminal records because we have so much identity theft in the United States. When you're convicted of crime and there's a record placed in the file, they don't put your social security number on there. They used to, and they used to put it for judgments, but they don't. They only put your name and your address and your date of birth. So oftentimes when companies are getting criminal records, they're just matching name and date of birth because there is no social security number to match. And that results in a lot of incorrect information getting on a file, especially if you have a common name. Okay, prevention, use exact match. Get it exactly right. Or use multiple identifiers. All right, identity theft, that's a common cause of inaccuracy. This is a little harder to avoid, to be honest. When that information comes in, it looks like the consumer. The bureaus don't know there's been fraud. So when they put it on the file, I don't think that's a mistake you can really avoid because it does come in looking just like the consumer with their name and their social security number. Now, once the bureaus are told that it's been identity theft or told it's not mine, then they have a duty to fix it. But the prevention for identity theft really comes down to the creditor. Now, the creditors, they don't want fraud either. So they want to verify that that person in their office seeking that loan is really that consumer. And typically they do when it's a person-to-person credit transaction. But these days, at least in the United States, it's all done online. It's all done in a computer. You want a Capital One card, you just go to the Capital One site, you enter your information, and they decide whether to give you a card. There isn't verification. And that enables identity theft. Okay, this has been talked about by some of the other speakers, and we see the harm caused by the inaccurate credit reports. And I point out the credit denial. But again, it's not just the consumer that's being harmed. It's the lender, it's the seller, it's everybody involved in that transaction. A job denied, that hurts the consumer when they're denied a job, but it hurts the employer too, because then they have to interview another person, pull another credit report. That wastes their time. And all these other things that can happen because of inaccurate credit reports. Okay, something to mull about later, maybe we have the panel discussion. I pointed out that the standard under the Fair Credit Reporting Act is reasonable procedures to assure maximum possible accuracy. But as I was thinking about that standard, I realized, why doesn't it just say credit reports must be accurate? It doesn't. It says reasonable procedures to assure maximum possible accuracy. Now, that's close. It's close to saying it has to be accurate, but it's not the same. That's a policy question. Should it be more strict and demand accuracy? Then what follows that is liability. Okay? And so what kind of liability should the CRAs have if a report is not accurate? Again, I mean, there's pros and cons. I'm on the consumer side, but I see the other side. Too much liability, that can hurt the system. So we have to strike a balance between protecting consumers and, letting our economy run efficiently. Now we get to the other important part of accuracy, the consumer's right to dispute, because there will be errors, unfortunately, but there will be errors, and the consumers can spot those errors because they know if their payment was late. They know if that account belongs to them. So the consumer dispute is an integral part of assuring accuracy. And what the law provides is that the consumer can dispute the accuracy or completeness of any item of information in the consumer's file. In this way, it's like your Credit Reporting Act. Now, what are the common disputes? As you would expect, they track what are the common inaccuracies. One of the common inaccuracies is status. So a lot of consumers will dispute if they see the status. In other words, the balance is wrong, or it's not been late, it's not delinquent, or there's a wrong date of delinquency. And the way this is corrected is you correct whatever's wrong with that status. If they say the balance should be 100 instead of 1,000, then the correction would be making the balance 100. The next area, I call this ownership disputes, and that's the mixed file and the identity theft, because then the consumer is not saying the status of the item is wrong. They're saying the item doesn't even belong to me. There shouldn't be any account on my report for Chase because I don't have a Chase account. And so the correction there is to remove the entire account from the report. Then public record disputes. These are judgments, tax liens. Now, what happens with a lot of these is, like I said, the status is wrong. It's been paid, it's been vacated, it's been released. So think if you have a tax lien, that means you didn't pay all your taxes. And then the government can place a lien against you. And that gets recorded in your county office, in our county office. I don't know how it works here. Okay, but if you pay that tax lien, then it gets released. So if it's not reported as released, that's very damaging. That's showing, let's say, you owe the government $20,000, but you actually don't owe the government $20,000. You paid it, it's been released. So the way that gets corrected is you put in the correct status. You say it's been released. Then the creditor can see, okay, this person had a tax lien, but they don't owe it anymore. That's more favorable than having an unpaid tax lien, especially in the United States, because the taxing authorities have priority on collecting debts. So having a tax lien is worse than having a private credit debt. Okay, so if a consumer makes a dispute to the credit reporting agency, as they have a right to do, what must the credit reporting agency do? Well, the Fair Credit Reporting Act is very specific about this. And one of those amendments around 1996, they changed it, and there was only a paragraph about what the CRA had to do with the dispute. They amended it, and they made that section 4 pages long. And they put in these provisions. The CRA must do a reasonable reinvestigation. They use the word reinvestigation of any information disputed. the CRA must notify the furnisher. Okay, so you've told Equifax, this account does not belong to me, let's say Chase. Equifax has to tell Chase that you're saying that account doesn't belong. The CRA must provide the furnisher with all the relevant information. Oftentimes consumers have documents or have information that shows that their dispute is valid. Let's say you say this was paid and you present a canceled check. Or you say it's identity theft and you have a police report that you filed as a victim of identity theft and you send that in. Whatever you send in to the CRA that's relevant, they have to pass on to the furnisher. And then the CRA, they must review and consider all the information you give them. I mean, that makes sense. If you're giving them information, they should look at it. And then, this is really key, this top one. The CRA must delete or modify information that is found to be inaccurate or incomplete or cannot be verified. In other words, if the consumer says this is wrong and they cannot verify that it's correct, they have to change it. In other words, the consumer's dispute is presumed to be valid. The consumer does not have to prove that the information is inaccurate. It's the opposite. The CRA has to verify that the information is accurate. And if they cannot verify the accuracy, they must change it. That's Congress protecting the consumer, not putting the burden on the consumer, but putting the burden on the CRA. Now, a corollary, and John's going to talk about this, as I pointed out, the CRA must send a dispute to the furnisher, and he's going to take it from here on what the furnisher must do. What?
I just wanted to, as regards the inaccuracy regarding the status, I think we should point out that under the Fair Credit Reporting Act, that if there's, if you've been delinquent on an account, that delinquency can be reported for a maximum period of 7, correct, Robert? And if you have filed for bankruptcy and you got a discharge in bankruptcy, that information can stay on your credit report for a period of 10 years. So sometimes the credit reporting agency may continue to report that you were delinquent on a particular account, or that you had filed bankruptcy and obtained the discharge beyond the 10-year period. So that would be reporting the status of your account inaccurately. And then in the area of employment, where they use criminal records, I believe they can report your arrest for a period of 7 years. 7 years, the conviction can, there's no limit to reporting convictions, is my understanding. Okay, going to the furnisher's duty to investigate. The furnisher must investigate disputed items after receiving dispute notice from the CRA. The procedure for disputing under the furnisher duty to investigate, which the furnisher here would be the equivalent of what we in Nigeria would term the credit information provider. Okay, so the furnisher is the equivalent of the credit information provider under the Nigerian Credit Reporting Act. So the furnisher, the way it works is the consumer sends a dispute letter to the credit reporting agency saying, the American Express account, I'm disputing it for whatever reason. The credit reporting agency will then send that dispute to the furnisher to look into the dispute. okay? And the furnisher must reasonably investigate that dispute. The furnisher must review all relevant information sent by the credit reporting agency, and the furnisher must report the results of its investigation to the credit reporting agency. Okay, if the furnisher finds the information is inaccurate or incomplete, it must report the results to all the credit reporting agencies. So if it gets the dispute letter, say, from Experian, it still has to send the results of its investigation to the other two credit reporting agencies. Okay, and that's where I was talking to Mr. Popola about this cooperation the need to cooperate between the various credit reporting agencies. And maybe that's something we need to discuss. Reports results to all the credit reporting agencies to which it furnished the information. Delete or block reporting that information to the credit reporting agencies. Furnisher must inform the credit reporting agencies if consumers dispute their account, and the furnisher has a 30-day period to complete its investigation. I believe there's an additional 15 days that they can take if they got a free annual report. Okay. And now let's go to how it really works. Credit reporting agencies send what they call CEBs, which is basically one or two words: "This is not my account." And that's all the furnisher usually will get. The furnisher will try and match it up and say, yeah, it's John's account. That's, in our opinion as consumer advocates, is not a reasonable way to investigate a dispute. I'm going to send, when the consumer is disputing the account, I'm going to send a canceled check, some sort of proof of payment that they paid off the account. In fact, the way I started working with Robert was we had a mixed file, father and son. The son had filed bankruptcy. So when we were disputing the account, we actually sent copies of the son's bankruptcy discharge to the credit reporting agencies. Unfortunately, the furnishers don't get to see that because, as I said, everything is automated. So they just send a one-word dispute inquiry to the furnisher saying he says it's not his account. Furnisher simply looks to see if it's the record. I've already spoken about that, to confirm whether the disputed information down on the litigation, at least in terms of furnisher liability.
Well, maybe that is the question. As I was talking to Marcus Green the other day, is why do they do these very simplistic, inadequate? And I'm not saying always. Okay. What do I see? I see the worst situations, right? I see the people that have tried to get it fixed and they can't. If they got it fixed, they wouldn't be coming to me. So maybe I don't get a representative sample, and I'll admit that. Okay, but I've seen some really bad situations where the consumer disputes over and over and over again, and that shouldn't happen. That's right. Okay, well, no, no. Uh, but okay, why don't they really investigate? I think it's really just a question of the system is computerized. The furnishers, they're not in the business of reinvestigating, or are the CRAs? They don't make any money reinvestigating. They make money selling credit reports. Okay, and they've computerized it. Now John raises this, but they get more litigation that way. That costs them money, right? Yes, but not. Then the number of lawsuits are in the hundreds. Probably the number of settlements is in the millions. I mean total. I think they save more than that by not hiring hundreds more investigators. And to do an investigation, you might have to spend some time. You might have to spend an hour or two, and they don't do that. And again, we have some representatives of the industry here, and they can tell why they do what they do. I'm not saying the Nigerian ones do that, and again, I'm not saying that all the disputes at the CRAs in America are like that either. Okay, most of them are resolved, but are there too many that aren't resolved? Well, certainly it's too many for that consumer. This is really a big problem. This furnisher simply looks to see if its records conform to the disputed information. In other words, the consumer says, my balance is 1,000, is 100, not 1,000. Well, the Chase was reporting 1,000. That's why it's on the credit report, right? The credit bureaus, they don't make stuff up, okay? So Chase's records probably show it's 1,000. So when that person at Chase gets a dispute and the consumer saying, no, this balance is wrong, all Chase is doing is looking at that data, which is actually what they sent in that was wrong. Their data says 1,000. So they're looking, oh no, I show the balance is 1,000. I'm going to verify that this is accurate. But they didn't go beyond that. They didn't go to somebody else and find out what is the real balance on this account. So we call that data conformity. All that the furnisher is doing is looking, does the information that the CRA have match the information on my computer? And most of the time it does match the information on the computer because that's what originated the information on the credit report. The furnisher has reported a $1,000 balance. They didn't report $1,000. They only reported a $1,000 balance because that's what their records had. That doesn't make it accurate. So that's a big problem. Let's see. Oh, and yeah. This is the provision that was added. This was added in 2004 to protect victims of identity theft. And what this says is if the CRA must block the reporting, that means remove it, of information the consumer identifies as resulting from identity theft if the consumer sends appropriate proof of identity, a copy of an identity theft report, and identification of the consumer. An identity theft report is typically a police report. It's a report that is made to a government agency by the consumer for which the consumer would have penalties of perjury or false swearing. So it's something that the consumer wouldn't necessarily normally lie about because they could go to jail if they lied. So typically it's a police report. And to me, this is Congress. What they heard in their testimony and the hearings on this was all these victims of identity theft that could not get their reports fixed. Months gone by, years gone by. And I think Congress did the right thing. They said, well, that reinvestigation system that the CRAs are using, that's not working because all these victims of identity theft are not getting their reports fixed. So we're going to tell the CRAs, we don't want you to do your normal reinvestigation. We don't want you to do any investigation. You just block it within 4 days. No questions asked. You get it, you get this information, you get an identity theft report, you block it within 4 days. Okay? Well, unfortunately, they're not doing that every time. It's way better. It's way better for victims' identity theft since they put this in. There's way more information that is being blocked. But I've got cases where they say, oh no, we don't accept your police report, even though it's a valid police report. So they don't block it. And they must notify the furnisher they blocked it. Oh, this was something that was in the part that John mentioned. Remember, he said when the furnisher investigates, they have to report the results back to the CRA. They have to report it to the other CRAs to whom they reported it. Again, protect the consumer. Dispute to Experian, then it gets fixed on all three. They didn't want the consumer to have to dispute 3 times. Okay, but another thing it said was they have to block reporting that information again. This is called the reinsertion. This was a terrible problem, still is a minor problem. What happens is it gets deleted, but then because all this stuff is monthly computerized reporting, it gets re-reported. The same wrong status or the same wrong account. And then, again, there's nobody at the CRAs that's screening this, so because it gets re-reported by a computer, it gets into the file. So Congress said, furnisher, when you realize you have inaccurate information that you've reported, you gotta delete that from your records and not re-report it. And they added a provision telling the CRAs that they're not supposed to reinsert the deleted information. That is still a problem, but not as big a problem as it used to be before they put those requirements in. All right. Okay, we're just about done with this section, but here some of the policy questions. These are very similar to the 2 I talked about earlier. Okay, the Fair Credit Reporting Act does not literally require that inaccurate information be corrected. It says it must be investigated, and it says it must be deleted if not verified, but we still find that inaccurate information is quote unquote verified. Which, it's pretty hard how can you verify something that's false, but they do. Should the law go further? Should it require that inaccurate information that's disputed be corrected, as opposed to just say investigated? And then again, if that were the standard, or even if it isn't, to what extent should the CRAs and the furnishers have liability? Now, I think this is a very interesting question under the Nigerian Consumer Reporting Act, because it does let the consumer go to court, and as the chief said, it says then everybody shall have their liability, but it doesn't really say what the liability is. It doesn't, and it says you can recover costs. It doesn't say what the damages are. So we do in our FCRA, as I'll talk about tomorrow, we do have a very clear definition of damages. But the question is, what should be the liability? Should it be more strict than it is? All right, I think that's it for this.
Thank you so much, Robert and John, for that paper. And the policy question continues, so we'll keep that. Maybe you take a note of it for what you want to answer or your contribution towards that for the panel discussion. So we're about to take our final paper for today. We want to take the next paper in another 30 minutes, and that will take us to panel discussion so that you can ask all the questions you have been noting down. And to take us in this 6th interactive lecture is no other person than Professor Olawale Ajayi. Professor Olawale Ajayi is a legal practitioner and the Professor of Legal, Social and Political Environment of Business at the Lagos Business School. He was an Associate Research Professor of Law at the Nigerian Institute of Advanced Legal Studies and later Group Company Secretary, Legal Advisor and Executive Director of Dunlop Nigerian PLC. He was variously responsible over time for giving legal structure to business transactions and strategy, managing human capital, marketing and strategy, as well as negotiating agreements, managing relationships with a wide variety of stakeholders and trade partners. His active participation in organized private sector bodies and in managing relationships with the civil society and government gave him useful insights and experience in stakeholder relationship management, as well as the interrelationships between the society, government, and business. At Nigerian Institute of Advanced Legal Studies, he was the project coordinator and wrote most of the project proposal and report of the British government-sponsored reform of court procedures in Lagos State project that eventually culminated in the introduction of the case management system in the Lagos State High Court and country. He is a trained negotiator and mediator. He teaches social and political environment of business, business law, and microeconomics of competitiveness. He is an alumnus of Business School, IESE Business School, Harvard Kennedy School of Government, a member of MBA, CIPM, IOD, Nigerian, CITN, IUCNS, Environmental Law Commission, and a fellow of LEAD, Leadership for Environment and Development. With a round of applause, let us welcome Professor Olawale Ajayi for his paper.
Well, good afternoon to you all. I was wondering who she was speaking about. I think that was my other life. Today we're concerned with credit reporting and consumer protection. Just give me a minute to load my presentation and then we'll be ready to go. So good afternoon to you all again. Can you hear me well? Or do you require me to use the microphone? I seldom do. I usually don't when I'm in class, but I think my voice is a bit hoarse, so perhaps I should. Right, so we want to talk about the consumer protection dimensions and trends in the Nigerian institutional context. And this is basically going to be raising some issues which hopefully will dovetail into the panel session later on. And I'm going to basically be looking at this from the consumer protection perspective. So first of all, let me dive straight in. It's a very short, hopefully it will be a very short discussion. I have only 3 slides. So I'm going to look at definitions, look at consumer rights, and then raise some of the institutional and contextual issues, some of which have indeed already been discussed or raised in earlier sessions. But I'll hope to give a sharper edge to the consumer protection dimensions. Right, okay, so the Consumer Protection Act, number 66 of 1992, really is the centerpiece of consumer protection legislation, consumer protection initiatives in Nigeria. And of course, it does not pretend to be a comprehensive legislation or a comprehensive institutional arrangement for consumer protection in Nigeria. However, the impression is that the and looking at the law, the act, the impression is that the Consumer Protection Council really has sort of specific remit for consumer protection in sales, service, credit transactions, as it ought to. But then there is scope for other regulators to regulate consumer protection issues in their space. So you have the central bank on consumer protection in the financial sector, NCC, telecoms, and so on and so forth. But if we come from the consumer perspective or the philosophy of consumer protection, then the Act gives us a definition of who a consumer is. This is not a word that is found in the Credit Reporting Act. So the question really would be, what type of consumer protection are we talking about when we talk about credit reporting? Rather, the word you find in the Credit Reporting Act is data subject and person. Data subject itself is not defined, or a guarantor or any person or entity whose credit information is administered by the credit bureau. NITDA's draft Data Protection Guidelines 2017 also, basically defines a data subject as an identifiable person who can be identified directly or indirectly, in particular by reference to an identification number or to one or more factors specific to his physical, psychological, mental, economic, cultural, or social identity. That seems to relate to an individual rather than to an entity. And that the NITDA draft seems to be more in consonance with the consumer protection definition of a consumer. But the Credit Reporting Act also uses the word person, and in the substantive section, it also talks about the person, the right of a person in that is it that triangle or quadrangle of the information provider, credit bureau, credit user, and the data subject or person. And it specifically defines person to include, of course, an individual, incorporated and unincorporated association. So basically it covers anybody or everybody, including government, state agencies. So that would be anyone who really is desirous of using credit. I guess it would not really be the philosophical consumer, therefore, that we are necessarily concerned with. However, there are 2 points. Most of credit reporting is meant to bring in the MSMEs and smaller people. So, and many of them operate as individuals, perhaps as partnerships. So the philosophical nexus is generally between a corporate entity, a provider, who is more learned, who has more negotiating power, than the consumer, who is generally seen as someone who is less empowered and therefore needs to be protected by the law. And so I don't think that we find this tension accentuated or pronounced in the consumer reporting, in the Credit Reporting Act. But obviously, in view of the fact that we are hoping to draw in more people who are at the low end of business segment into the credit industry, that must be a consideration that we want to bear in our mind, that the essence of the law would be to try and look out for them relative to the better endowed and better providers from a philosophical point of view. Now, speaking directly, what are the rights, legal rights, that one could pick out from the Credit Reporting Act? And I tried to list them, not necessarily using language. I thought of maybe I should use similar language to what you have in the United States, but I think probably we can draw that out at the panel discussion. However, most of the key rights in the United States will also be found in our Credit Reporting Act anyway. So the first is the right to play and be remembered in credit extension space. Essentially, what this is looking at the positive aspect of credit reporting. In other words, credit reporting is meant to allow more players to access credit. And by virtue of having credit information available, the idea is that you are empowered, to be financially included. So that is, you may say it's a positive spin, but that essentially, I think, is the policy, is actually the core policy behind the Credit Reporting Act and the Credit Reporting Initiative. And so if you look at section 3 and 5, that speaks to that policy perspective of credit reporting. A right to accuracy of and reporting of information. This is very fundamental. And I think Tony Idigbe has already raised some of the issues that we'll have to look at as far as this is concerned. And much of section 3 is devoted to that. I think you have the act, so we can just look at the opposite sections as we go through. A right to free and prompt correction of inaccuracies. So obviously the act anticipates that there may be or will be inaccuracies, and these inaccuracies could or can and should be corrected. And I think from a policy perspective, you would expect that the judiciary ought to take this into consideration. After all, the judiciary is essentially inserted in policy making. It's not just technical interpreting of law, and judges have to remember that point of view, that they're also policy makers, and their decisions also contribute to policy. So it would be grotesque to come from a basis that there ought not to be any inaccuracies whatsoever. However, reasonable or due diligence, the ordinary negligence standards ought to be expected. A right to an annual free credit report from a credit bureau, and the president should either nod in the Nigerian way or in the Indian way if I'm correct or if I'm wrong. You know, the Indians do this, and you don't know whether they're saying yes or no. I don't know. Anyway, we do apologies to any Indians that are here. Right. A general right to privacy and confidentiality of credit information. General. I don't want to go over the exceptions, but as you read the sections, you will see that there are derogations. There are times when there are legal requirements for for reporting. If you've issued dishonored checks, you can't insist on hiding under the cracks and so on and so forth. A general right to authorize release of credit information. So essentially, the idea is that your consent is required, except for those legal circumstances when information has to be released by virtue of legal requirements. A right to use a credit report only for the transaction to which consent has been obtained, section 9(4). A right to restriction of information to users who comply with formal credit reporting statutory processes, data exchange, used for permissible purposes, except I think in section 9(e) or so, where the person or the data subject can give permission for their information to be released without the existence of a data exchange. What's it now? Agreement being in place. Someone, I think, sort of cast some doubt on that. But if we look at it from the positive point of view, if the idea is that credit information will allow you to access credit, I don't think that that is really something that is fundamentally bad. It probably may result in compliance compliance cracks, but probably from the point of view of functionality, it's probably something. Once there is consent, the fellow needs the credit, will get the credit. I think from the systemic point of view, that is probably not anything that is very bad. The issue really has to be, does the data subject know their rights? And we'll speak to that later on. A right to restriction of information, I think I've gone over that, yeah. A right to disclosure of the credit bureau that issued a negative credit report. Obviously, credit bureaus really, well, so to say, don't issue negative credit report. They report on what your status is, and if that status is not good, you don't get credit. Although there is some interstitial, what do you call it now, paradox in this in the legislation. It sort of says credit bureaus are only supposed to give information without commentary, but it then also requires them to do scoring, and I think maybe we may want to consider, the legislation does so, but I'm wondering whether the scoring is in some sort of a commentary. But if that is within the four corners of the legislation, well, it's probably 2 + 2 = 4. But from the consumer perspective, you then really have to say, what's the policymaker really about here? Is it the scoring that matters, or is it the information that matters? And what would be the what do you call it now? What would be the mischief? Mischief to the consumer, and then could that become a subject of legal dispute? And our lawyers are nothing if not inventive, and that could be a point to examine. A right to timely, free, and fair amicable dispute resolution, which, listening to the central bank, exposes some grave cracks in the legislation. Because the legislation seems to suggest that central bank will take an active role. And we did hear from point of view of practice that central bank says, well, it's between the credit bureau and the data subject, so you guys sort yourself out. So obviously that would be a default that could open the credit bureaus to undue risks. This would even be an issue of possible liability of the institution, Possibly there could even be what is it now? Recourse to a remedy for a statutory tort by way of the central bank not fulfilling legal duties that are, placed by the act, thereby resulting in what do you call it now? Injury or loss. So possibly that could be opening the central bank to a huge avenue of liabilities in statutory tort. That's if things go wrong. A right against discrimination, obviously your color, ethnicity, and so on are not to matter. A right to action for gross negligence, criminal and civil redress for violations. Well, I have CRBs and CIPs, but actually it includes also users. So it's not just CRBs, CIPs, but also credit users. And I think Chividigwe has spoken to this. But I would prefer to take the consumer side and to say that vested rights cannot be divested except very expressly. I mean, legislation is not supposed to divest vested rights by, a slap at the back. So the fact that it is not expressly mentioned, I think, should be taken as not as excluding the right to negligence, ordinary negligence, but probably as accentuating the need for all the parties involved to exercise extreme caution, which would mean they require insurance. All right. Now, to mount a suit in negligence, that ought to be taken away expressly, or it should not be by of longhand necessary implication. And of course, there are criminal and other civil actions. A right against identity theft, probably not so expressed in the act, except by way of implication, in the sense that you have to give consent, and there would obviously be how do you call it now, need for due diligence in taking that consent. But of course, under the Cyber Crimes Act, there is a specific provision against what's it now, identity theft. So I guess probably that means we need to think a bit more clearly about the need for or not, and perhaps including clear provisions in respect to identity theft in the Credit Reporting Act. It's a big issue in other jurisdictions, and I don't see why it will not be, especially as we have more digital transactions. Now let's look at some of the institutional and contextual dimensions and issues. Well, the level of awareness of rights by consumers in all areas, not only in credit reporting, is low, and there is apathy to seeking redress. The consumer protection culture, or the to consumers by business persons, governments, is not very high, and the courts, especially the Supreme Court, has restated this on several occasions. More so in the commercial merchandising, sale of goods, and so on. But here also, as you have more digital transactions, that is something also to bear in mind. So it's obviously clear that people don't yet know the benefit they have, or they will have, if they are within the credit reporting ecosystem. Otherwise, you would expect that they would willingly get involved. There's also a low level of awareness and adoption by prospective users, which I think has been discussed sufficiently. There are data protection and security issues. We don't yet have a comprehensive data protection act, and we have hodgepodge of protection around the place. There's a legislation that is coming up, but the level of shall I say criminality and the lower level of detection, enforcement are issues, not just for credit reporting, but there are very visible issues in business and national space at this point in time. And sensitive information is there, ensuring that there is sufficient discipline to protect that information is a work that has to continue, and I think it's a big work in progress. There's not that much respect for privacy or for rights as we should have it. Dispute resolution, the process issues have been explained. There are gaps and apparently some need for tidying up in the act. There is a regulatory issue, which even the gentleman from Central Bank has mentioned. We also see judiciary, the case, long-term case, where 50 billion naira was awarded. It's remarkable, isn't it? Because I wish somebody would make a mistake about my own credit information too, and that could win me an early retirement. And so these are areas where you need wholesale thinking by all regulators and all institutions. I think the effort has to be to empower and encourage credit reporting, not to how's it now, not to hamper that. It probably will be, even though I'm not speaking now for as like a consumer, but this may be, now I'm arguing the other side, where in negligence is always the courts always have the discretion whether to allow negligence liability in any particular area, and where there will be the possibility of a floodgate of claims, or claims that will be fantastic and may hinder commerce. Generally, the judges ascribe discretion either to limit or to refuse to admit that area to negligence liability. So perhaps for those of you who may be arguing for the credit bureaus, those will be arguments to prefer to the courts. They ought to take a public policy perspective in terms of their approach. There's no doubt that a balance will need to be struck. There's a psychological perspective that even though MSMEs talk about inadequate access to finance, in truth, and we had a conference last week on financial inclusion, digital financial inclusion here, because we run a research project on that. And one of the things that came through was that the typical entrepreneur, the typical MSME, is still very uncomfortable about taking credit. It's something that we will probably have to investigate a bit more in our research. But that was one of the things that came through, and it was restated by several people that even when you say come and take credit, say I'm not going to take it until I know deploy this credit. Well, there's benefit there, but that may also be the reflex reaction of low level of financial literacy, which also suggests that if people think that money is a grant, they'll take it. But if it looks like there will be consequences, then perhaps they will be a bit less eager to take it. So I think work needs to be done at that level. We probably shouldn't assume that people are making time to want to raise the case. Then we also need to be concerned that people do not take, what do they call it now, they do not become overextended. So it's not just now not getting credit. You don't want people to now take too much credit or to get unduly attached to credit. Those will be issues, but I think those will be later in the day. Coverage of digital transactions, and I think the president did say that they are capturing digital transactions. But I think you are doing that as a business development effort. It's not necessarily a legislative central bank. I said, well, the guideline says payment service banks are not to do any lending, but don't count on that, because bankers will always look for loopholes. And if I can't do it directly, I may do it through a subsidiary. And does CBN have the regulatory bandwidth to to monitor that? It seems to think, okay, the payment service bank thing is there, the telcos will only do payments, but that's not true. And I assume if you look across Africa, you see Orange is there in Ivory Coast. Actually, mobile money is bigger in Ivory Coast than banking. The bankers are like orphans, and I think that's the future Nigerian banks saw, and they've been fighting against the entrance of the telcos. And what does is it MTN or Vodacom do? It's just to what's it now? Collaborate with somebody. They offer the loans, you do the payments, and the Ivorians don't really see why they need to go to a bank if most of everything they need they can do it online. Now the point there is that for the formal services, you probably can still get some credit reporting, but digital finance means you can access credit from all over the world. Will those get reported? So those are the issues that we need to and the timeliness of reporting is also something that we need to think of, because if I have 15 transactions close in a month, are those going to be on the books when on Wednesday you are reporting, or are some of these transactions not going to be reported? Anyway, these will probably you probably say this will be minuscule transactions, but we want to expect that digital transactions are going to grow as we go on. And the final one I would like to raise is that, can CPC play? In other words, can the Consumer Protection Council come into this space? And I don't see why not, because even as of now, the CPC enters into memorandum of understanding with various regulatory bodies insofar as they think that consumers are not being sufficiently covered, which is good, because they don't more or less say we're the super policeman and we can invade your space. But if they think the NCC is not adequately covering something, they talk to NCC, have a memorandum of understanding, and try and ensure that that area is very well covered. I don't have much faith in the central banking's consumer protection initiatives, and I even think it's impractical to think that for all the transactions can be centralized at the central bank, and that seems to be the mindset of the central bank from way back. So I think obviously there are going to be issues there. Even in the Credit Reporting Act, it's fantastical to think that when there's a dispute, it will only be at the level of the central bank, or the central bank will be an active interloper in the process. So I think those are some of the issues that I hope will have us thinking from the consumer perspective. So as I said, it's more to raise questions rather than to give answers. I hope this, and I hope that I have done this creditably well. Thank you very much.
Thank you once again, Prof. You're asking us to whether you have done it well. I don't know what we are supposed to do. We are the students. We are taking your position now just to tell you that you did that so well, sir. Thank you very much. And that will be the last paper for today. We are now going to have our panel discussion. Please, can we have seats out here in front? Please, all our speakers, please, can we come forward? It's now time for you to ask your question on all, or make a point from all you heard today.
Okay, so thank you very much. I must commend the stamina of the audience. We've been having almost straight lectures, and it's remarkable that you are still here. And I hardly saw anyone, I didn't see anyone dozing during those sessions. I saw a few people, of course, but not too many people were dozing during the session. So can you give yourself a round of applause? And I think that we must also give the facilitators a round of applause, because it has been very interesting, it has been very enlightening. I guess that's why we couldn't afford to sleep, because we've done a lot of learning. And you've also been very disciplined, not to want to jump in as we will normally do in Nigeria. So you can jump in and jump all over the place now. And I hope you will have something to say rather than just keep quiet. I think issues have been raised as far as credit reporting is concerned. We've gotten some view of how all of this started, or how it's done in the United States. And I think one of the key areas is that in the United States it's more about consumer transactions. Here is almost specifically about credit transactions. May I just say, if we have, let's start in this way. If you have questions that to any of the sessions, let's first take those questions that you have been burning to raise. Yeah, so let's start that way. And you can throw your questions to specific persons or generally, so that can clarify some of the issues. Please, also, you can sit down. Just let's have your name, maybe very briefly where you work, just two things. My name is this. I work at here. Keep the comment brief, and then ask your question, so that we can give room for more people. Yeah. Oh, okay, thank you very much. So let's take a few more questions. If we have to allow you take second question, how many will we allow others? Thank you very much. Yeah, Umuna. Yes, thank you. Maybe when we come back, we will be able. Yeah. Thank you. Let's try and just go straight to the questions, please. Thank you. So that we can take as many questions. Yeah. I think, okay, Chinaya, Rufai, then we can move to this side. Let's just be quick with the question, yes, please. Rufai, and then we'll take some responses, and then we'll come this way. Sorry, Rufai, yeah. Thank you, ma'am.
Okay, can we answer some of these questions now so we don't lose track? Who wants to start? I think you have had the first.
Yeah, thank you very much for the questions. I'm happy that people actually listen to the presentations. So let me start with Frederick. You talked about the effort of the regulators. What's been the effort of regulators to stimulate this industry? That's how I will view your question. I think I want to really credit the central bank for what they have been able to do. Because if not for them, there's no way we'll even be where we are today. Apart from the fact that they enabled the regulation that started in 2008, which was revised in 2013 after 5 years of experience. Because that first 2008 regulation was without prior experience. So, and that could speak to what Rufai was asking. Part of it, I'll take that as well. So, but thereafter, for all institutions under the purview of the central bank, it's compulsory that must have a relationship with at least 2 out of the 3 licensed credit bureaus. And that relationship includes the fact that they must submit data of all borrowers on their platform at any point in time to at least 2 credit bureaus. And when they want to also, review any application for credit, they must also check on the database of those 2 credit bureaus to which they have data exchange agreements. So that means that at any point in time, they do 2 reports on every application. In addition to the fact that you also have to check their own CRMS. That makes it 3. So the way they have done it is that they've taken it one after the other. Initially, it was all the commercial banks. After that, they brought on board the microfinance banks and other institutions like the mortgage institutions, the development banks, the leasing companies, all those companies that, all those institutions that report to them. So that's what they have done. Secondly, they've done quite a lot of capacity building for themselves to be able to get their own staff to understand what this is all about, what's the best way to monitor what the banks are doing in terms of compliance, in terms of data submission, and so on and so forth. The CBN also assisted to put us together to have what we call a common data template. So in which case, everybody now submits the reports to the bureaus using a database, using a common template. Before, each of us have our own way by which we took data from data furnishers, but not anymore. So it's a standard template. So if you prepare your data, you can just click send to CRC, send to CR, send to XDS. And that's why today, actually all the banks actually join the 3 credit bureaus, because that's easy for them to do. So, and then they do some level of awareness creation as well. Secondly, on insurance, Umuna, what products do credit bureaus have for insurance? This is one industry that we've made all attempts to bring in. I was sharing with when we were having lunch, that I had the privilege to engage in ICOM when Mr. Fola Daniel was the commissioner, and he granted me an opportunity to make a presentation at the conference of the CEOs of the insurance companies. Thereafter, I've made presentation to the chief risk officers of insurance companies in Nigeria. Thereafter, I've engaged NIA also to say we can design a portal, we can dedicate a portal for you as insurers. First, to motivate people to pay over time their premium, but also to guard against multiple claims, which is also very prevalent in your industry. We haven't had much successes. For my bureau, I think we have just about 7 insurance companies that have joined us now. And so from there, we then begin to move to every insurance company to do that presentation one by one. And that is what we have been doing. We have products that can be used by insurance companies. We think they should leverage on that. Uchenna, does a credit bureau go searching for how do we capture, how do we collect information, how do we get our information? That's not the question. Okay, so I didn't get that question. Let me then go to Rufai. Maybe I'll come back to you, or maybe somebody else can take that. Rufai, so you are right. By the 2008 regulations, data furnisher must get the consent of data subjects. Before they submit your data, you have to sign. I give you power to submit my data. And then before they also check on your credit history, you also sign a consent to say you are free to check my credit report. But what we discovered was that those who have bad loans, there's no way you can get them to give that consent. So that's first. The second question is, if you have taken a loan from me or you have taken my goods on service, I can give you the terms and conditions upon which I will give you, part of which is I should be free to put your name in one data. So because that money doesn't belong to you, it's unlike deposit. And I think that's what we should look at. So today in the 2013 regulation and in the Credit Reporting Act, consent is not required for you to submit data to the credit bureaus. But you still need to notify that person or that entity that you have submitted the data to the credit bureau. And that, the law says, it can be by email, it can be by text message, it can be by anything. Okay? But however, if you want to access anybody's information from the credit bureau, you need to get that consent. And you need to get it for every transaction. So it's not going to be sufficient that I've gotten one, and therefore I don't need to get it again. But the way around it for a lot of institutions is that you sign, like for instance today, virtually all account opening packages of the banks have that clause that a lot of people don't read actually before they sign. Then of course for loan, before that terms and offer and conditions, they already put it as part of the things that you have to really say, I'm okay, go ahead and check me out. So that's the way it is today. The only question I haven't answered because I didn't understand this is Uchenna's question.
Somebody had a question to Social Security number no longer included in criminal record.
Yes. So the question was, why don't they include the Social Security numbers in the public records, because that would be a very useful identifier to avoid mixing files or making errors on the credit reports. And the problem of identity theft, the public records in the United States, which we're talking primarily about court records of judgments or criminal convictions, or tax lien records, which are in the public records, those are public. That's why they're called public records. In other words, anybody can access those. And with computers now, a person can just type into their computer, give me the state of New York's criminal records from this county. And therefore, if they had the Social Security numbers in there, it would really be a gold mine for identity thieves. They could get, millions of Social Security numbers along with the name and address and the date of birth of that person. And so to prevent those thieves from getting access to the Social Security numbers, they decided they wouldn't include the Social Security numbers in the public records. They did not have the alternative of making the public records private, because under our American law, they must be public. So they said you won't include the Social Security number.
If I may just add, like most of the litigation now, most of the filings in America are electronic filings. So for instance, if I'm going to file a complaint, I don't walk to the courthouse any longer. I file it over my computer. And most records, they do require, most court records now require redaction of personal information. So for instance, in my bankruptcy filings, typically in the past, we would include social security numbers, but now we don't. We include only the last 3 digits of the person's social security number. Date of birth, we redact. So those things are provided for in the court rules, again, because of identity theft. But those records are public. Anybody can go online and go and see them.
I think I understand your question, Uche, now. You would ask whose job is it to grow the credit system of a nation, right? And you also ask whether the credit bureaus go searching, go get data outside of the banking industry. I think it's probably everybody's job to grow the credit system of a nation. Clearly, the lenders have an incentive because it's a way to make more money. I'd say the government also has a role to play in not being or not presenting an obstacle to such economic growth. I will say that from research that I've looked at, credit system or the credit reporting system has worked much more effectively when the lenders themselves came together and agreed to share credit information. And private sector has provided services. That's the way it developed in the United States. There wasn't any government initiative that forced banks to share information. They were already doing so, although regionally you'd have credit reporting systems in the eastern part of the United States. You have a different one in Atlanta, serving the South. You had a different one in the West. And then when the FRCA came, now just went ahead, buying all the regional credit bureaus. But they were already sharing information. And the obstacle actually was there were laws that prevented banks from doing interstate banking. So when those laws were restricted, banks just went crazy and began to do business. So I guess the question then would be, what makes those societies different? Why were they willing to come together? They understand that there is a value to sharing that information. Because of information asymmetry, the applicant will never divulge information that will prevent from getting credit. So the banks were getting burnt. So at their meetings, they probably decided, let's start sharing information. They didn't see it as competition, the way perhaps banks or insurers in Nigeria may see sharing information as competition. They saw it more of, we have business to do. Let us help ourselves do better business. So yeah, so having said that, I think in countries like ours, as Tunde already mentioned, the IFC has a program to help to develop credit reporting infrastructure in Africa. I remember when I started my journey here in Nigeria, I kept going from bank to bank, and some banks were, they were ready to actually, they realized that they actually needed to share information, and they talked about the fact that they did share information, though not in an automated fashion, and they don't always divulge the right information also. For instance, I had someone tell me that if they gave a loan that has gone bad, and the customer goes to another bank to attempt to get new loan, and the credit officer from that bank calls them, they will actually give inaccurate information because they want that bank to grant the credit so that that person can come and pay them. It's really crazy. So there's something about trust in our society that is kind of lost, and maybe I'm just speculating, and that's probably the reason why we don't seem to get things going that benefits us. And the IFC and so all my efforts, they were paying off, but very, very slowly until the central bank, through the IFC, even I went to the central bank and they said, okay, go and do what you need to do, but there wasn't a lot of support until the IFC came in there, persuaded them to, you need to do this for your economy, and then, of course, they came out with regulation, and that helped us a great deal. So it's everybody's job that has something to gain, right? But mostly the people that have the power are the lenders themselves and the government. With regards to getting data that could help to provide more richness, especially for what they call thin file customers who never borrowed before. It's really, we have an incentive as credit bureaus to go gather that data because we can make money off of it. we can help the banks find more people to lend money to, and in the process will make money as well. So that is our job, I think.
Thank you very much. Just to add that for us to improve access to credit, in addition to whatever the association will do, the regulator will do, we as Nigerians have to change. We have to change, and there are some deep issues of value that is at stake here. And if you do some research, there's some relationship between credit reporting, the entire credit infrastructure, and bankruptcy and insolvency. You know, because bankruptcy talks of what do you do with somebody who didn't pay. And if you go historical, in the Roman Empire, what they did was they liquidated the person. You know what I mean? They divided his body amongst his creditors. They liquidated the person. And then later they changed it and said, okay, instead of liquidating the person, we liquidate the assets of the person. You know? And then, in addition, we make the person lose his reputation socially. To lose his reputation socially. And then you had Emperor Augustus who said, no. What if the person is not at fault? Should the person, even if we liquidate the person's asset, should we also allow the person to lose his reputation? So they made a distinction between a fault bankruptcy and a no-fault bankruptcy. But that didn't last long, because soon after the collapse of the Roman Empire, and you had the Italian states, and then you went to all the other states in Europe, they reverted to making no distinction between a fault debtor and a no-fault debtor. And they treated all of them exactly the same way. They liquidated the person's asset, and the person lost reputation in the community. And sometimes you had to wear a special dress, and so that people will know that you are the debtor who didn't pay. And you know, also we probably have similar ones in Nigeria, but around stealing and other criminal offenses in our traditional society, where you have to wear snail shells. Yeah, so it took a long time, right up to the Victorian times, for them to agree that, well, whether you are a fault or no fault debtor, we could sort of allow you, particularly if you are no fault debtor, to be discharged. In other words, for it to be cancelled completely, and we forget the fact that you owed. And so that's why they talk about discharge. Discharge means that we've forgotten about the debt. But it's as simple as that. If you listen to the presentation from the facilitators from America, even if you are discharged as a debtor, they will still keep it in the record for 10 years. So effectively, you're actually effectively discharged 10 years when the record will disappear. But at least you are legally discharged. Immediately you are discharged, which means you can still incorporate a new company, you can still start business, where people will know you had some problem before, but it's not a legal impediment. So they will have to make the judgment whether they will do business with you or not. And then that goes on. But somewhere during the early times, say the Italian times, the Italian states after the Roman Empire, if you were a debtor, you were accountable. And so if you were owing, you couldn't leave your house. You have to stay in your house. Because if you leave your house, particularly to travel abroad, there's a presumption that you are trying to do what? To flee from your creditors. And of course, there will be harsh consequences against you. So that culture of accountability became imbibed by the people. The fact that they are accountable, that it is expected. And then it then transformed when you started having the royal charters, and then you have the Royal Nigeria Company, you have the Far East India Company, the Hudson Bay Company, going around the world, that culture of accountability transformed into an accounting culture. So they went to the village to collect money from people on that expedition to go on an exploration. You have to keep record. Like, you have to be in your house. You have to keep the records, and then when you come back from the expedition, you're expected to account to those you took money from in the village, those you took money from at the wharf in London, which was how banking also started. You have to account to them. So that culture of accountability evolved today. Now, the question is, what is the culture we have? If you gave money to your brother to do a business, does he feel a sense of accountability? Does he keep the record? And there has been a lot of research. In my paper, I refer to one working paper that was done by some people sponsored by USAID, and there are some people from CBN and the rest in Nigeria. And part of what they found with medium and small scale enterprises in Nigeria is that there was financial indiscipline. They kept poor records. Then, of course, there's some factors that were not within their control, like they had limited skills or knowledge, deep enough to be able to do the business. Then there was poor corporate governance. You give somebody money, you are supposed to be a shareholder in the business. Because he's in charge of operations, he doesn't have meetings. They don't have AGM. He doesn't send quarterly reports, accounting reports. Those cultures don't encourage accountability. Then, of course, there's the poverty, the fact that everybody is struggling to get out of poverty. And so, if he gets money from you, he thinks it's just for him to get out of poverty, and doesn't feel there's an accountability to society. And should I say Doyin or father of credit reporting, mentioned the issue of social accountability. We have to deepen social accountability in Nigeria to have access to credit. So when you said you walked to the bank and they said you should bring money and deposit before they can give you a credit card, the question you should ask yourself is why? 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 And it takes you back to all I have spoken about. So it's not just the responsibility. Of course, the CBN, when CBN started the CRMS, the purpose was to change the credit culture. Ultimately, it is not going to be CBN that will give access to credit. All this infrastructure that is being set up is geared towards changing the mind of the Nigerian, the attitude to credit, a sense of responsibility to pay. All this infrastructure is doing is to set consequences for failing to recognize that social accountability. But the idea is that when it gets to a certain stage, it will move automatically, because people will then become socially accountable, and therefore financially accountable, and therefore the credit providers would have more confidence. Everything is going to crash. Like the suggestion was made that, CBN should reduce the interest rate, as if that will solve the problem alone. No, it cannot. We still have to keep addressing these infrastructure problems, but the aim is to change the attitude of our people, and once we achieve it, we are going to have access to credit.
Could I just make one quick comment? When you said you went to the bank and they asked you for a deposit in order to open up a credit card, Robert, there's secured credit cards in the U.S., so it's not something new to Nigeria. People in America who have filed for bankruptcy, usually the credit card company is not going to give them an unsecured credit card, as the chief has tried to point out. There's consequences. So usually the first thing you would get after you do bankruptcy would be a secured credit card, and after a period of time, that secured credit card will now become unsecured when you rebuild your history.
Thank you very much. Let's take, I think we'll have time for maybe 3 more questions on this side. If you just do a few seconds, we can take more persons. Yeah, starting with you. Okay, maybe one more. Do we want to take the cocktail at 5, or we want to? Oh, sorry, the cocktail is tomorrow. Yeah. Do we want to close at 5, or do we want to? You want to hang out with us at LBS for another 15 minutes or what? Yes. Okay. Repeat that again, please. Let's just take one more. There's a gentleman at the back.
then we can try and yes. Okay. Thank you very much. Yeah, okay. Can we take those questions? Thank you very much. Although we have stated, and I think most of the facilitators have stated today, that there is a high rate of default amongst SMEs, and that is why banks don't want to do that business, and that is why there's effort to build the infrastructure to encourage them to do that business. The reality is that there are a couple of other research that show that micro borrowers have a higher percentage of repayment, actually, and then they pay much higher rate of interest. So whereas let's say you get from the bank 30% or 28% or 25%, right, from a bank loan per annum, many of the Esusu type of arrangements that are done, cooperative, they pay maybe 5% a month, and they pay back. A quick turnaround, small businesses, you know, and they pay back. But if they held that money for 1 year, it would be 60%, and most of them do pay back. So your friend is probably knows that he's sitting on a very good business. But that having been said, right, he's supplying them the equipment, so he knows the business, right? He knows the market. So I can presume most likely that he's probably he knows about the raw materials that machine will process. He's probably the off taker, so he actually probably buys off whatever they produce. So it's probable that he's the one to pay them to pay him. So it depends on the structure. There are so many ways you can structure the transaction and control the receivable and the cash flow, you know. So I don't think he's relying just on giving them the machine. There may be some other complex transaction that he has structured there. In addition, he may have also taken additional securities, personal guarantee, which give them access to their BVN, and assuming they were diverting the money, and assuming it was actually a profitable business, which I want to assume because he couldn't have given them machines for a business that is not profitable. It means that even though they are low today, tomorrow they may be more effective, they may have more money. Now, assuming they diverted that money through what we are talking about, credit reporting, BVN, and the rest, you know, maybe if they then go somewhere a few years later to collect money, they may have an experience that would make him to carry cake to the office of so, so it's not as simple as that. With respect to the unstructured individual money lender, in many systems you have what we call private lender, which is what you are talking about. It's not unusual. In Canada, where I practice, we have private lenders. You have bank as lenders, you know, so it's not unusual. Clearly, that person would take advantage of the provisions around consent. So consent could be one of the ways the person will be able to have access to submit and to get credit reports. So it's something that can be dealt with. Will fingerprints help? I just think that, well, maybe I'll leave it to those who have more experience from America, but because this is all data-driven, it's electronic, the whole process we're talking about, it could. But what I've seen under the Nigerian law, if you look at the section 3, one of the subsections, it says that the credit bureau shall take reasonable step to verify the accuracy. And so that's a standard that's a little bit different from the American standard. And so the question is, what is reasonable step? I remember I did a case in Nigeria, but this has to do with securities. Before it became fully electronic, what used to happen is public record, so I can talk about it. I can even talk about the parties. What happened in that case was, before the electronic system came up, the stockbroker does a transaction in his office. They put it in a disk, carry it to the stock market, close the transaction, and then bring the disk back. So what happened was that when the disk came back, they didn't verify the transaction, whether it was what they took to the exchange that came back. And so there was this other smart guy who was conniving with everybody and was selling off other people's shares. And so the matter came up. It's a popular case. Let me not mention the party, even though it's a popular case. So the Securities and Exchange Commission found the registrar liable for negligence on the basis that they should have verified when it came back. And they said it would cost them so much money to verify. Why should they invest that money? So they appealed to the Investment and Securities Tribunal, where I defended Securities and Exchange Commission, and they lost, because we were able to show that they needed to take reasonable steps, and that they are because it was their staff who was involved, to control their staff, and they had breached one of the codes, that they would take reasonable steps to supervise their staff. And all they needed to do was just verify that, have a system that they can verify that what came back from the exchange was the same thing as what went there, and they didn't do that. So there are certain standards that you can use to deal with that. So depending on the amount of money that may be involved, it's possible that that could come in, particularly as they have access to the BVN, etc. now. And then lastly, why rely on the data from the furnisher or the credit information provider? You know, I think most of us, there are lots of lawyers here, particularly young lawyers. So I will ask you, why rely on the CTC? Why rely on CTC? There are certain presumptions that are existing in your evidence. They taught you evidence for 1 year in the university, taught you evidence again for 1 year in law school, isn't it? So the system is organized in such a way that, you know, the system can only work on certain presumptions. If I tell you all the presumptions on which the entire system works, you know, you will just think that it's what they call magic, government magic. Even money you spend, even the money in your pocket, what is behind it? It's just a piece of paper. But there are certain presumptions that are behind it. So it's the same concept that has been used to make sure that we can live together in society. There is a presumption of reliability. There is a presumption that that bank is regulated by CBN, which is run by your own tax money, and that they will do it properly. But if you can prove in any specific case that it was not done properly, then that will be the exception, and we deal with it. Thank you.
I want someone to add because some of this type of lending is done using algorithms. So I want you gentlemen to speak to that. So sometimes some of these people say we really don't need credit reporting. We'll use algorithms to, apart from the fact that sometimes these MSMEs are more, especially women, are more faithful in the repayment. So but that's a new thing. So I hope you will speak to that.
You have support.
Oh, up women, right?
I think that I just want to add to what you said about some presumptions. And I think we also have to understand that we're in the business of trying to make money. Unless you have information that the entire setup, this whole idea of credit reporting, lenders that need to part with their money, okay, they're not in the business to make. They're in the business to make money, and they face risk. Whenever we talked about information asymmetry, right? Because before the lender even comes to the credit bureau, you've approached them as an applicant for credit. You've already developed some information, okay? You've told them your income, your address, and things like that. What they want to do is to verify that information. That's why they come to the bureau. You understand? Self-reported data is not necessarily trustworthy because you can only part with information that makes you look good. You understand? And once the lender has done business with you and they have a file of that business dealing, and they report it to us because there's value in everybody sharing. That's why we have a full file credit reporting in Nigeria. It helps for other lender you might go to understand that you're already indebted or exposed to somebody else. So now the system is really based on presumptions. So unless we see evidence that that system is not working for most people, then we can really then begin to have questions about it. Because what I was going to ask you was, how do you want it to be designed differently? You understand? But we can have that discussion after, because you understand. But realize that you have a right when you're denied credit to get a copy of your report. There's a reason for that. Okay? There's two types of errors that can be introduced in a report. The type of error where a bank mistakenly reported erroneous information about you is called type 2 errors. And I think Sola mentioned, or maybe you mentioned about the fact that the lender that you went to that denied you credit because information was wrong in your report, they didn't know your information was wrong. You got that report, you saw the information. That lender has lost a business opportunity if information was actually inaccurate. If it was corrected and you're actually a good risk, that lender wants you to come back and reapply. So really, everybody is interested in making business opportunity. So don't assume that somebody is out to get you, because your question assumes that somebody is about to report erroneous information about you for what? Now, obviously, credit bureaus like to, before the agreement that they exchange with the data furnisher, they ask for your RC number, are you registered at the CAC, and things like that. So really, it kind of, besides the banks, right, who are already formal institutions, you know, licensed by the CBN, there are other data furnishers, and the credit bureau has to make sure that they're actually registered entities, you understand? So there are presumptions, but I think they're correct presumptions until we can prove otherwise. So I just want to say that. With regards to fingerprinting, remember that the BVN is based on you, your fingerprint has been taken, your picture has been taken before you are issued an ID. It's up to NIPS to make sure that you're not registering twice. You don't have two numbers in the system. So the only thing we have to worry about is whether lenders are accurately reporting your BVN. Sometimes they get it wrong. We've seen situations where a lender is so lazy, they went to one school, maybe try to open an account for like maybe 200 students, and they use the same BVN for all of them. That's very, very negligent, and we have to clean all that. So our algorithm will catch that. When we see the same BVN for names that are not similar, we know there's a data quality problem, and so we'll let them know that, look, you've issued the same BVN for more than one person with similar name. So we do some of those checks. You ask about the cost, the quantum of damage to the data subject. I think I already addressed that. There is no intent to damage. If somebody was denied credit because of erroneous information, they have a right to see that report. Once they fix that information, they can go apply for credit again. It's only where there is a legitimate dispute or disagreement between the data furnisher and the subject, then they can possibly, according to the law, maybe go to the CBN, which is not the CBN is throwing that back at us, right? But really, we also allow the data furnisher and the lender to put a comment on that account, so that anybody who sees that report can see that there's a dispute. But ultimately, the last place of redress is the court system. Go to court and things like that.
All right, thank you so much. Let me ask all of us, how many of us have obtained our free credit report at all from any of the bureaus? Free credit report. So you are entitled to 1 free credit report a year. And if you have never done it, please go to the website of any of the 3 licensed credit bureaus. You can, through the website online, get that information at no cost to you once in a year. And so when you get that and there are still issues, then you can then take it off from there. Then Gbemisola, the person selling equipment, I think he should try to join a credit bureau. A credit bureau is good for his business to know the creditworthiness of the people he is dealing with. It's also important to put those data in the credit bureau, and it will serve 2 purposes. One is that it will give confidence to him for repayment, and you will let them know your data is going somewhere and this is the implication. But much more also is that there's what we call mainstreaming. It could also give those people opportunity to also take more advantage of the fact that they have good credit history and leverage on the financial system to take other forms of credit. So that's why I said in my presentation that this credit bureau thing is not just about negative or punitive or it's a black book. Good guys leverage on it to also get good reports, to get good money and at very good cost as well. So when we get data, and we're talking about reasonableness now, part of the things we do, okay, so let me just say this. We got the data from a microfinance bank. And what my guys will first of all do is to aggregate the total value of all the information that's submitted. So this credit bureau, this microfinance bank submitted loans balances of 200 customers. And when we added it, it came to about 9 trillion naira from a microfinance bank. So clearly, directly, something is missing. Or sometimes we just look at a bank has submitted data of about 1 million, 1.5 million customers and come to about 60 trillion naira. And we know the total credit in the economy is just about 20 trillion naira. So something is wrong there. So what has gone wrong? Sometimes, like in the case of the microfinance bank, we just discovered that for a particular customer, they just put 999999999 that amounted to 9.9 trillion naira. So that customer has paid back its loan. They are just submitting for that file to be closed. But rather than just put 00, the guy put 99999. So that's changing. That's part of reasonable test. How many credit subjects were submitted previous month? What's the value? How many are submitted this new latest month? What's the value? What are the variances? So we use some level of just scientific analysis and trend analysis to see whether we could find out something. Sometimes it's just about exchange rate. So a customer had taken a loan of $10,000, or let's say $10 million. And we say, report all of this in the currency in which those loans were taken and leave the conversion to us. But sometimes the bank already did conversion on their own, and they still leave it as is in dollars. So when it comes, so that's like $10 million at 305, at 305 again. So do you understand what I'm saying? So this is the kind of thing, these are the kind of things that we see that we leverage on to be able to clean up data. And then we most times get the data back to the furnishers and say, this is the total number of subjects to submit data on. This is the value that it comes to. Is it correct? And sometimes they say, no, there's something wrong. And then we try to figure out how we can deal with that. Sometimes it's very difficult to do. We have a case of a set of twins whose names are date of birth. The names are almost the same. One is Elijah, one is Eli. And all the names started from the same thing. So the system, just like the case study that we'll be doing tomorrow, I've just gone through it. Every time we try to process, the thing keep on merging them as one entity. Because factually all the information look similar to the system. And so and it's much more in Nigeria, where Muhammad Bello is just like Tunde Pokwala is a common name. So the northern name is the most difficult ones. It's just, there are so many Mohammed, there are so many Ahmad, there are so many. So what can we do in the absence of unique identifier to do all of that? So we have processes that allow us to do all of this. But there always be one mistake or the other. And so there's that process of complaints, there's process of demerging, there's process of letting them know we've done this and all of that. Finally, I think okay, so then somebody has said, why do we rely on this on the data providers to do this? It's the same way that people are asking when they submit data, why are they paying to submit? Okay, so there are institutions, they are joining the bureaus and you are asking them to join with a fee. A bureau is like a club. Okay, you join to become a member because it's not open to everybody. So when you are joining, it's just like when you are going to a Ikoyi club, you pay to join. Okay, but you pay so that you can take advantage of a better, a bigger platform. So your own data is just one data. Other 1,909 institutions are also submitting data, and you are leveraging on that. Okay? And when you get there, you have joined, then you want to buy various products. That's where the bureau makes their money. There are so many products that the bureau have. So whichever one you buy, you pay for it. Okay? But the fact that you can have opportunity to submit information because you have joined is a great privilege. And there are laws that this exchange of agreement is there. Apart from the Credit Reporting Act, you also need to have that data exchange agreement between that institution and the credit bureau that talks to specifics of responsibilities about data, responsibilities about updates, responsibility about informing your subjects on what needs to be done. Thank you very much.
I'd like to say thank you very much to all of you for the patience. I think the questions session has helped to deepen our understanding of the subject and to begin to address some of the more practical issues. Tomorrow is another day and we'll get into some more depth. I think some of those other questions, please just keep them on the cards, and I'm sure we'll be able to get to them tomorrow, God willing. May I say thank you also to the facilitators, and of course I would like to hand over to Ebele now. Thank you very much.
So we have come to the end of